What is unfair is a minor political party who hasn't complied with the law being allowed to nominate candidates to compete against them and to serve as spoilers. And that's what's going on here.
Good afternoon. Please be seated. Sometimes in cases like this, there's not enough room. All right, on the record, today is Friday, August 2nd, 2024. This is the time set to address a complaint that was filed in this case by Nevada State Democratic Party versus Nevada Green Party to address declaratory and injunctive relief concerning Nevada Green Party's ballot access qualifications, and that was filed June 10th, 2024. We've had an amended complaint that was subsequently filed that's been challenged as well, and a motion to strike by Mr. Benson was filed, and that motion to strike was filed on July 15th, 2024. To my understanding, those are the two pending things that we need to address for purposes of today's hearing. The parties in agreement on that?
Yes, ma'am.
Okay, and to my understanding, so for Plaintiff Democratic Party, I've got Todd Bice and Daniel Brady, is that correct?
Yes, Your Honor.
All right. Mr. Benson on behalf of Nevada Green Party, correct? And your name, sir?
Greg Ott with the Attorney General's Office on behalf of Secretary of State Francisco Aguilar.
Okay, Greg Ott.
Ott, O-T-T.
Okay, thank you. And for the record, there were filings by the Secretary of State in this case as it relates to or applied to brief in opposition to plaintiff's first amended complaint. All right. It's also my understanding this hearing is being recorded both on our system as well as at the request of the media, so as long as we're in compliance with the requirements, that'll take place. I want to address a few things before we get started with each side making the presentation. A few issues that I'm looking at and want the parties to address. Number one, not having a basis on my own to address all of the exhibits that have been provided, as well as go through the thumb drive, exactly how many signatures are being challenged, and specifically why, if we can address that. I also want to make sure I and the parties address what's the standard that we're addressing and who bears the burden with respect to each thing, with regard to the signatures, with regard to the contents of what was circulated for signatures. Are we talking about substantial compliance as it relates to the statutory requirements? Are we talking about clearly invalid in terms of measure? What are we talking about? And I want each side to address that, all right? And then I've got some additional questions as we go forward. Let's start with plaintiff in this case. Ed, proceed.
Yes, Your Honor. Thank you very much.
All right.
Sarah, I will, as I go through what we plan to present to you today, I will endeavor to answer your three questions, but I apologize. The last topic you asked us to address.
So the first one was how many signatures were needed and from which
Correct.
districts. Second one was, I think,
Burden of proof.
who's got the burden of proof, and then the standard that we're applying. There's There's the
Oh, that's right.
substantial
Yeah.
compliance in terms of what's required, and then clearly invalid.
Correct. All right, thank you. Yes, thank you, Your Honor. For the record again, Todd Bice on behalf of the plaintiff, the Nevada State Democratic Party. Your Honor, we're here on a challenge to who may appear to compete on Nevada's upcoming ballot in November of this year. And both the U.S. Supreme Court and the Nevada Supreme Court have made clear that the state must engage in regulation in order to restrict or limit who may appear on the ballot. Because you can't just say, well, I want to be a candidate for X, or I want to declare myself to be a political party, and so therefore I am allowed to appear on the ballot. The ballot would become, as other courts have explained, completely unwieldy and would be extraordinarily confusing and deprive voters of an orderly and fair process.
I understand all of that, I agree with that. I want to cut to the chase as much as we possibly can.
Okay.
I also appreciate the fact that, considering election challenges that have been presented in the past, we also want to have integrity in how we proceed with these types of things.
Yes, so I'll jump right to the facts then. The facts are, I think, straightforward and really effectively undisputed. And that is, and we have a PowerPoint, Your Honor, and could we'd like to pull that.
All right.
I provided your clerk a hard copy if you would like a hard copy of it as well, Your Honor. I don't know what's easier for you, the screen or the hard copy.
It's going to depend. Right now I need to reach for my glasses because some of the hard copy is very small. But we'll see how it looks. Okay.
All right. Your Honor, I don't think there's a dispute about what the affidavit requirement is. That's actually set forth in the Nevada revised statutes as well as the Nevada Administrative Code. And the Green Party knew what the correct affidavit was. In fact, their exhibits that they said that they provided to the Secretary's office contained the correct affidavit. What they claimed happened was after they submitted the correct affidavit, there were other problems on the form that the Secretary pointed out to them that the form was wrong because it didn't have a blank for or didn't have an identification on who the minor party was, and it didn't have anywhere to note the petition district. The petition district is very important when it comes to qualifying here. So the Secretary's office, someone sent them the corrected form, but with the old affidavit on it, or a different affidavit on it. And the Green Party never corrected that. So the affidavit is the version that we show you here on our first slide on page 1. It sets forth the 6 requirements are, and number 5 is a very significant requirement in this regard, because what it says is the person has to certify under oath that they believe each person who signed was at the time of signing a registered voter in the county of his or her residence. And here's why that is so critically important, because there's only one way in which you can certify that, is that you talk to them. You have to have talked to the voter yourself in order to certify that, in order for you to have a belief that they were a registered voter. And so, going to slide number 2, I apologize. This shows you the affidavit that they actually use. And when you look at this, it was apparent, it should have been apparent to anyone that they had a problem. Because what it says here is, this is an affidavit, Your Honor, for an initiative petition. So the person who is purporting to sign this is representing that each person had an opportunity before signing to read the full text of the act on which the initiative or referendum is demanded. Well, that's not possibly true. There was no referendum, there was no act, there was nothing for people to be shown to read. So this entire certification here, this entire affidavit, is just not true. And it never was true. And so, Your Honor, when you ask the question, of how many signatures are we challenging. We're challenging all of them because the Green Party agrees with us that just like in LVCVA, every affidavit was wrong.
So correct, what I'm understanding is there's a subset of issues. One being the requirements as it relates to compliance with the petition requirements, as well as the signatures, the irregularities, that type of thing. So when I'm talking about the number of signatures that are deemed to be invalid versus ones that might be valid, I understand the issue that's raised with regard to the affidavit, and that applies to all.
Got it. So, Your Honor, the reason we raise these other issues, all right? The reason we raise those is, and this ties back into the burden of proof. You'd asked this a very important question, and in fact, you look at the SIR reply that the Green Party submitted. Most of their SIR reply is arguing over and over that the challengers have the burden of proof, this extraordinarily high burden of proof, and they don't have sufficient evidence. We don't have sufficient evidence. You hear that over and over throughout their SIR reply. And that actually is the exact backwards of what the law is in Nevada. Because if you look at the LVCVA decision, Your Honor, and whether you call it fortunately or unfortunately, I have a lot of knowledge about this case because it was one of my cases. If you look at LVCVA, what the Nevada Supreme Court said is point blank, is that we do have the initial burden. I agree with that. As a challenger, we have the initial burden. But our initial burden is met once we establish that the affidavits were wrong. And we have established that because the Green Party admits it. Once we met that burden, the burden actually shifts to the Green Party. The Green Party, and this is on page 683 of the Supreme Court's decision, 124 NEV at 683. That Supreme Court explains that the burden is appropriately placed on the proponents of the ballot issue. Quote, because they caused the situation when they failed to review the current statutes and comply with their requirements. So we agree.
What page were you on right there?
I was on page 683, Your Honor, the Nevada reports, at 124. We agree that actually the standard is substantial compliance.
Okay.
And what the Nevada Supreme Court's explaining in LVCVA is, when you are the proponent of the either the initiative, in that case it was an initiative, or here you're the minor party, the proponent of the petition, the burden shifts to you if you are now claiming that you substantially complied with the law. In other words, if you're going to say that the court should excuse our non-compliance, our failure to comply, if you're going to excuse that, you have the burden of proving to the court all the facts that are necessary to establish that excuse. Whether you're going to call it estoppel, whether you're going to call it some sort of constitutional challenge, or whether you're just going to say that the statute, we satisfy the requirements of the statute in some other fashion. If that's your argument, you actually have that burden of proof. You have both the burden of proving it and you have the burden of persuasion because of your non-compliance. And that's what LVCVA established. So I think it's important to sort of understand the context of what happened in LVCVA. Because it relates to one of the one of the arguments about substantial compliance they are making. They are arguing that the clerks have validated the signatures. And they base that on a statement in LVCVA where the court just kind of in passing makes a statement that, well, maybe there could have been substantial compliance if the clerks had validated or the signatures had been validated. Because here's what happened in LVCVA. When the initiatives, the signatures were submitted, I sent a letter in LVCVA to the Secretary of State. The Secretary of State did not realize the effective affidavit. I had recognized the defective affidavit before the signatures were submitted. So I submitted that letter, and I told the secretary back then, 2008, all these signatures are invalid because of the defective affidavit. The secretary, and this is what is set forth in the opinion from the Nevada Supreme Court, what the secretary did is, the secretary then informed the county clerks that the affidavit is wrong, and you must not certify any signatures where there is a wrong affidavit. So when the clerks came back, they all said there are no valid signatures because the affidavit is wrong. Here,
Which in this case had happened the opposite way.
well, here it happened the opposite way because the secretary didn't know about the defective affidavit. And we couldn't have known in advance because this is not publicly available information. We only learned about this after we were able to obtain copies of the initiative, of their ballot petitions. Unlike an initiative petition, which is online at the Secretary of State's website, or in LBCDA, it was because we'd actually earlier filed a challenge based on single subject and the description of effect. So the defects in the affidavit were known, not identified, but known prior to the submission of the signatures, which is why we were able to get in front of the secretary in advance during that case. Here, that couldn't happen because the defect was not known, was not disclosed to anyone, including my clients. So the clerks, the county clerks, are not alerted to this problem. Unlike in LBCBA where they were alerted, they weren't alerted to this problem. They go ahead and treat all these signatures, all these petitions as valid. And then they proceed to do the sampling. Under state law, if there are a certain number of signatures, you can do a sample. All right, so the reason we're raising all these other problems, Your Honor, is they infect the entire sampling process. Because no one in the secretary's office, apologize, my phone beeped. I thought I had it turned off, Your Honor. No one in the secretary's office alerted the secretaries to the problems in the entirely defective circular's affidavit or the other problems that we have identified. And so all of the entire sampling process was compromised with these other problems. So when the Green Party says, well, under LBCBA, there's that passing reference to, and I like the word, the court says maybe, maybe this problem could have been solved if all of the signatures had been verified. And I think that's important because if you look at the footnote that the court, and I believe it is footnote 33, my memory might be wrong. No, it's footnote 50. If you look at footnote 50 in LBCBA, where that passing statement is made that they are now, when I say they, the Green Party is now claiming to, they cite a case actually from Missouri in that footnote. And what happened in that Missouri case, I think is very important and very significant distinction. In the Missouri case, the law is different. And the court validated, or I'm sorry, the local election officials validated each and every signature, not a sample, each and every signature. So the court there said, well, because, and the court, and the Nevada Supreme Court points out, the signatures were actually verified in that case. Not sampling based upon other defects, but actually verified. That did not happen here. By the clerk's own acknowledgement, and by the Green Party's own acknowledgement, what actually happened here was they, I apologize, there was a slide I wanted to show right here. What the clerks did is they just did a sample. They took 500 signatures, defects and all, and they did a sample. And then they came up with a percentage based on that, and then applied that percentage across the entire universe of petitions. And the problem with that approach here, when you have all these defects, is you've now infected that sample with these. So you can't then extrapolate and say, all right, well, let's just take out the defective signatures and then multiply the validity rate against the remaining signatures. Because the percentage of the validity rate was based upon a sample of the entire set, not some subset. So that argument that they have spent a lot of time on in their cert reply simply doesn't work, even if this court were to accept the premise that that dicta in LVCVA, we submit it was dicta in LVCVA, somehow worked, because we don't believe that it did. And I apologize, it's not working again. Oh.
Your laptop is not connected.
Laptop is not connected. All right. Thank you, sir. I appreciate your help. So, turning back to the sort of substance of our point here. The Nevada Supreme Court has made clear with the LVCVA decision what is the legal consequence if you do not have a valid circulator's affidavit. And circulator's affidavit is actually quite important. And that's, if you look at LVCVA, the court went into a little bit of that history and explaining how these affidavits came to pass. Because this was in 2000, so the LVCVA case came out in 2008. It's in 2009, I believe, is when the legislature amended the statute here. That's an issue here where they updated the requirements for the circulator's affidavit. Because what LVCVA laid out from other prior cases that had happened before and would prompt the legislature start adding some teeth to these circulator affidavits, is there were what were known as signing parties. Signing parties, what happens there is some of these people are actually paid by the signature. And that actually happened here. The Green Party acknowledges that they paid some people for signatures. What the legislature has previously determined has happened in those instances where people are being paid is because there are a lot of initiatives in the state of Nevada, and there are a lot of not even legal initiatives, but petitions against certain things. Petitions, you can sign a petition today in Las Vegas in support of Israel, you can sign one in support of the Palestinians. There's always opportunities or people making requests to sign various petitions for various things. And what the legislature was calling out here and guarding against were these signing parties where, since there's a lot of signatures floating around the state through these various signature gathering companies, tracing signatures from one initiative onto another one in order to qualify for the ballot. That's why these certification procedures are so critically important. And I'm going to highlight for you some of what we think was going on here, based on the evidence shows what was going on here, that I don't believe the Green Party can really dispute. I mean, we have circulators' names being deleted and changed. That's not possible. That is plainly illegal. You cannot have a circulator's name on a document for verification by the notary, and then have somebody cross that out and sign their name in place of it instead. And that happened in this case in a multitude of instances. So what our point here is, it's not our burden to prove substantial compliance. It's the Green Party's burden. And they can't meet that burden when all they want to complain about is, well, the secretary gave us the wrong form, even though they knew they had the right form. Or they knew they had the wrong form because they previously had the right form. They can't meet that burden. And then they especially can't meet that burden when they have no explanation for all of these other improprieties in their signature gathering. And the reason I cite this, Your Honor, again back to LVCVA is the Nevada Supreme Court has reiterated that there's really only one legal remedy when the circulator's affidavits are wrong, and that is all of the signatures have to be stricken. So in this case, there are no valid signatures because all of the affidavits are wrong, and I lost the connection again. All right, I'll just have to proceed. Because I don't want to hold you up. So if the court, and again if the court looks at page 3 of our PowerPoint, we just list several of the cases, and these are all the cases relied upon by the Nevada Supreme Court in explaining that when you have an invalid circulator's petition, the consequence is that the signatures are invalid and the signatures cannot be used and counted in order to qualify for the ballot. Whether it's a candidate, whether it's an initiative, either one, it simply isn't allowed. And again, we are going back to sort of what the excuses that they have offered as part of their substantial compliance arguments are. They have really 3. They say that the signature by the verification of the sample somehow negates the need for the declaration. That just, as I've just articulated, that isn't plausibly the law. And they can cite none that any validation, let alone of just a sample of signatures, a small sample at that, would somehow qualify. Then they claim that their business practices are sufficient, which the LBCBA expressly addressed and expressly rejected that argument. And then lastly, they repeat the same constitutional arguments that were raised in LBCBA, which the Nevada Supreme Court similarly addressed. So again, I've touched on already the number of problems that we have raised. I'll just kind of walk the court through what we have pointed out here. Again, all of which defeats their argument and their burden of proving substantial compliance here. If you look at this page here on page 8 of our PowerPoint here, we just give one example. This is a circumstance where, again, we don't even know when the Green Party name is written in there. We have somebody else's name written at the top. The law here, Your Honor, is you actually have to prepare this form and you have to file it with the Secretary of State's office, right? So it'll say, typed up there would be Nevada Green Party. And if you look at a number of their petitions, they actually have that. So let me give you another example. Here's an example that shows you the form they actually submitted to the Secretary of State. It actually has Nevada Green Party typed on it. But there are lots of circumstances where they took a blank petition and somebody at some point, and we don't know when, hand wrote in Green Party, not even Nevada Green Party. I don't know if they're claiming they were part of the National Green Party or what, but that's what they wrote in. It's not even the same document that they had filed with the Secretary of State's office that they were out there circulating, which, again, the law doesn't permit. But then, this one I think is another prime example. This is page 9 here. Here, we have the circulator's name and address being changed. You couldn't be a circulator and have put your name on this and then have it changed. You can't have, this is just illegal. You can't not plausibly claim, well, the person that actually circulated put their name down as a circulator, and then in order to get it notarized, somebody changed crossed that person's name out and wrote their own in so that the notary would sign. And they did this on multiple occasions. This is page 10. Another example of this. Again, somebody changed the circulator so that they could get a notary to sign it. This is what we're talking about when we're referring to these signing parties. Right? They've got a notary sitting there, and the person who supposedly circulated this document apparently must not be present. So somebody just crosses out their name and signs it themselves. And that was done on multiple occasions throughout this. We've also pointed out, because we were genuinely very, very confused by this individual, I do not want to mispronounce his name, because he goes by a couple of different names. And I'll just call him Gregor, because at least I can pronounce his first name accurately, I think. And Gregor we thought this was very, very interesting because we found that he had submitted hundreds of signatures, hundreds and hundreds of them, but they were always notarized by only one person. And that was a Mr. Hanson, who is the member at large for the party. And we've raised that issue with the court. We pointed that out. I know Mr. Benson raises it. He argues in his reply that the statute, that he doesn't have a financial stake, and because he's a notary public, etc. I don't really care whether or not they want to argue he didn't get some additional consideration. The fact of the matter is, and we cited case law for this, admittedly from other states, state of Pennsylvania, pointing out you have a financial benefit. You are a financial beneficiary if you are a party leader, which he's the at-large member, and you are the one doing the verifications. And again, we've got this individual who has a name that he uses, and he suddenly got hundreds and hundreds of signatures. By the way, he's got signatures from both Clark and Washoe on the same day. And he submits this, and then it's only this person who notarizes his signature. That's what we have been pointing out. You cannot claim you have substantially complied with the law because somehow you can just assume these signatures are valid, which is what the clerk's offices, they did, because the secretary never alerted them to any of this because the secretary didn't notice it.
Do you have an example where this individual had signatures from Washoe and Clark in the same day?
I do, but I don't have it right in front of me, and during my rebuttal, I will have Mr. Brady locate that. Because I know we talked about it in my office, so I know we have it somewhere.
Okay.
And then if you go even to what they are calling their curative, or what's being characterized as curative declarations, where they say, well, we've got two declarations, we can explain this away. They actually don't explain it away. They actually only expose the impropriety here. What they say is, all circulators and circulator managers that I trained were trained to ask potential signers if they were registered voters in the state of Nevada and the relevant petition/congressional districts. But now look at the next affidavit, right beside it. They have this declarant, Ms. Hanson, has a different version. She says that Nevada Green Party circulated ballot access petition using both volunteers and paid. I instructed the circulators to ask every petition signer if they voted in the 2022 election and if they are a Nevada resident. Those are two different things. Those are two different things. And by the way, neither one of them are what the statute requires. They have to be registered to vote at the time of the signing, not some prior election. They have to be a registered voter at the time of the signing and a resident of the petition district in which they are signing. That's what the statute actually requires. And of course, the only way you could know that is if you were the one to have talked to them, which is why, again, the improprieties in the circulators being substituted out to make these things look legit. And this exact argument was made in LBCDA. Because in that case, they had, as the court knows, they had missing provisions from the declaration. And the proponents of those initiatives came forward with an affidavit from the chief executive officer of the signature gathering company saying, this is how we teach people to gather signatures. And that should be somehow sufficient. We've satisfied the statute. And the Nevada Supreme Court said, that's just not right. Because what you're saying is, this is how you, quote, train people, but you don't actually know that they follow the training. You weren't there with them. You didn't gather the signatures yourself. So who knows what these people were telling the signers? And that's all the more when you've got blank initiatives. Or not initiatives, you've got blank documents. They don't even have the party name on it. Somebody writes them in at another point in time. It's not even the document that they were authorized to circulate from the Secretary of State. And then you've got other initiative signers. Here's one, Your Honor. They have a slightly different version of what they were. of what they were asked, or told to ask. I asked every potential signer if they were a resident of Nevada, if they were a registered voter, and if they wanted to sign a petition. That, of course, is different than what we just saw from the other declaration where they're saying, this is how we were asking people. It's always, the story is slightly different, none of which is based on, I talked to people, we had to ask them if at the time they were a signed registered voter and the county of his or her residence, because this has to be broken down in the petition history. And then, sort of lastly on this point, Your Honor, the last argument that they make is, well, it's unconstitutional to enforce the law against us. And they blame the secretary for this. They say that, well, we had the right affidavit in our first form, even though the form was wrong. We at least had the right affidavit. The secretary sent us the corrected form back, but the secretary included the wrong affidavit. And that should relieve us of responsibility for the failure. And again, this is the exact argument that was made in WCBA. And that's, of course, that's just not the law goes. And that's all the more important here, Your Honor, when you're talking about candidates for partisan party elections as opposed to initiative petitions. Because here, and we cite to you a case from I think it was the middle of the District of Alabama, is my recollection, involving the Reform Party. And the court there said, it's actually, and I apologize, Your Honor, I have that case here. So make sure I give it to you. Yeah, it's the Reform Party of Alabama versus Bennett, and it was 18 F sub 2nd, 342, 1998.
You're gonna have to do that one more time.
Yeah, I'm sorry.
That's okay.
18 F sub 2nd, 1342, 1998. It's from the Middle District of Alabama. And the court just at the end of the opinion, because it's many of the same issues there, Your Honor. In that case, the Secretary of State of Alabama gave them bad advice. And they missed a filing deadline. The Reform Party missed a filing deadline, and they got kicked off the ballot. And they claimed, well, that's not fair. And the judge explained, well, what would be unfair is to let you on the ballot when you didn't comply with the law and allow your candidates to compete with those who didn't, because that violates their rights. And then, so I'll just quote what he said, what the judge there says, allowing the Reform Party of Alabama to disregard clear legal deadlines, even under the facts of this case, would violate the rights of the other parties which follow the law and the rights of its candidates. And that's why this Nevada State Democratic Party is here. It has complied with the law. It is qualified as a major party. So it can nominate candidates that appear on the ballot. What is unfair is a minor political party who hasn't complied with the law being allowed to nominate candidates to compete against them and to serve as spoilers. And that's what's going on here. So that's why we have the right to challenge this. These signatures are not valid. They did not comply with Nevada law, actually or even substantially. And the Nevada Supreme Court has expressly rejected this argument that, well, the Secretary of the State's office made a mistake. If the Secretary's office made a mistake, you don't get to benefit from that by saying, well, they made a mistake, so let us on the ballot, because that violates the rights of everybody else. And by the way, the Nevada Secretary of State's office clearly didn't mislead them. You'll notice they don't submit an affidavit from anybody saying we detrimentally rely upon what the Secretary told us. And why don't they do that? Because they actually knew what the real affidavit requirement was. In their draft that they sent, they had the right one. It got changed when the Secretary sent the form back, and they didn't bother to correct that. And they didn't bother to ask the Secretary, well, why is this declaration different than the statute? Because it couldn't plausibly be right when it talks about a referendum. It couldn't plausibly be right when you're saying, when you as the signer are swearing under oath, under penalties of perjury, that you showed the signer the initiative or the referendum for passage. There was no initiative or referendum to show them. And that's why, again, Your Honor, that's why they cannot claim, and they don't use the word estoppel, they try and sort of dress it up as a constitutional challenge. But there can be no estoppel argument here, because if you're claiming estoppel, your reliance would have had to have been reasonable, and that's what in the Reform Party of Alabama case, Your Honor, the judge pointed that out. You can't plausibly there claim that your reliance was reasonable because you knew the right date, and the secretary just told you the wrong one. Here, you knew the right declaration requirement, and you're complaining the secretary just told you the wrong one. You have a legal obligation to get clarity on that then, and to read the statute. And so I put up this comparison from LVCVA. What was in LVCVA, Your Honor, is on the right. What's in the current political guidance is on the left. The language is not nearly identical. You are all warned. Everyone is warned, whether it was on an initiative in LVCVA or for minor political parties, that the guidance that is being provided by the Secretary of State's office is for information only. It does not have the force effect of Nevada law, regulation, or rule. And instead, you are required to go look at the most recent version of the Nevada revised statutes and the Nevada administrative code and satisfy yourself about what the requirements are. I don't know why they did not do that, but they did not do that. And this, it is prejudicial and unfair to those people who have complied with the law to qualify for the ballot, to allow someone who has not to appear on the ballot. And so we ask that under LVCVA, Your Honor, the law has to be enforced, the signatures have to be disregarded, and if they're disregarded, then there is no circumstance in which they can qualify, because you have to submit 2,524 valid signatures for each petition district. And they have none.
So my question to you,
Yes.
actually I've got a couple of questions for you, but my question to you is, setting aside circulator's affidavit,
Okay?
do you contend that the irregularities that you've otherwise argued somehow cause the petition to not substantially comply with what was required?
Yes. The other defects we have outlined foreclose the Green Party from satisfying their burden of substantial compliance. And here's why, Your Honor. Because we acknowledge that the number of signatures, right, if you just use the raw count and you subtract out the numbers, we acknowledge that that does not reduce them below 25, 24 in any district.
And Mr. Benson, in his reply documents, has indicated if we take out the things that you're talking about, he still technically meets the numbers as it relates to those petition districts. Do you dispute that?
I do dispute that, because what he does, and I think that's very interesting, I have marked in my brief here, Your Honor, because look at what the charts that he prepared. I think they're quite informative. The charts he prepared, I'm going to go to tab, I believe there's 2. Yeah, it's tab 2 of his certified.
Right.
So he lays out a chart where he takes the raw count, he takes the number of signatures we have identified as having these various problems, right? And then he subtracts those, so he then has a new raw count. But look at what happens next. He uses a validity rate based upon the prior sample that included all of those defects. And therein lies the problem. You can't claim that, just like in LVCVA, had the secretary pointed out, you shouldn't be counting these signatures, you cannot rely upon that validity rate. He's trying to take a validity rate from a sample of defects and then extrapolate that and apply that onto these other signatures and saying, we're still good. That's the problem. He can't, it's his burden.
You're saying the errors that have been identified invalidate that validity rate?
Yes, because they've infected it. There's no evidence that they were excluded from the sampling process. And again, if you're the person advancing substantial compliance, that's your burden to show how the sampling rate occurred, and you're trying to extrapolate it now, that's your burden, not ours. And they readily concede, they have no evidence. What they try to do is when I say they, the Green Party tries to shift the burden onto us to say, we have this heavy burden of invalidating of their petitions. And the Nevada Supreme Court says, no, you, as the proponent, who messed up the circulator declaration, if you're going to claim substantial compliance, you have the burden of showing that you met every criteria of what that circulator requirement is. And here they're trying to say, well, we met it sufficiently because we have a sufficient number of validated signatures, and they don't. They have a sample that was validated, but that sampling included all of these defects.
My other question is, there was reference, and I can't remember in which one of the briefs, I might have been Mr. Benson's brief, is it related to a response. The clearly invalid standard under Las Vegas Taxpayers Commission versus City Council. Does that have any application here in your perspective?
No.
Related to NRS 295?
No, and that standard applies, that standard would apply if we had not met our burden in terms of the invalid affidavit, right? I actually agree with him on that would apply. Because generally speaking, that's the standard that applies when someone challenges an initiative. So, you know, because most of the litigation surrounds initiative petitions, I'll give you just an example of that. If I challenge an initiative as violating the single subject rule, or I challenge an initiative as having a defective description of effect, right? The burden is on me to demonstrate, because it is a restriction on the Nevada constitutional entitlement to present initiatives, the burden is on me as the opponent to demonstrate clearly that it should not go before the voters. That does not apply here, particularly when you have a defective declaration, a circulated declaration, because that's what LVCVA addressed. And LVCVA says when the declaration is defective, the burden shifts to the other side, the proponent. They have to satisfy. They have to prove to you that all the requirements have otherwise been satisfied in some fashion. And that's why I appreciate all the math that was done in the SIR reply, but it doesn't solve the problem because it was a sample and an infected sample at that.
All right.
Thank you, Your Honor.
Mr. Benson, you ready?
Yeah. Kevin Benson on behalf of the defendant Green Party, and I want to touch just very briefly on the issue regarding the timeliness of the new challenge to all of the circulator applications. And in this case, the amended complaint was filed in 21 days after the original complaint was filed. And the plaintiffs make this argument that, well, it relates back to the original complaint because it's the same facts, transaction, occurrence, etc. And essentially what they're saying is that anytime you file a challenge to qualifications of a minor party, that essentially any basis for those qualifications whatsoever necessarily relates to qualifications and therefore necessarily same transaction, occurrence, and it relates back. That is really not the law in this case. Under NRCP 15, I recognize that that's liberally construed to allow relation back, but only where the original complaint put the defendants on fair notice of the facts that were the basis for the claims. And that's in Nelson versus City of Las Vegas, 99.548 at 556, that's 1983 case, where the court says, on the other hand, interjecting as opposed to the liberal construction, where an amendment states a new cause of action that describes a new and entirely different source of damages, the amendment does not relate back, as the opposing party has not been put on notice concerning the facts of the issue. And so in this case, the original complaint mentions the circulator affidavit 5 times. The first time was simply to say that it's part of the packet that's turned into the county clerks. The other 4 times were to allege that certain individual affidavits were invalid because they had alterations to them. Those were the only allegations in the original complaint about the affidavits. And so there was nothing at all in the original complaint to put the Green Party on notice that they were going to be challenging the affidavits for any other basis other than these alleged alterations. And they could have, there was no reason why they could not have brought the complaint regarding all of the circulator affidavits as the original complaint, because clearly they reviewed them. They would have seen that it was a different affidavit. They could have brought it then and there. And also, I disagree with his contention that there was no way of them knowing that there was a problem with this affidavit until long before they filed the challenge, because it's true that these are not, to my knowledge, published on the Secretary's website, like initiative petitions are, but they could have done a public records request, as they did later on in this case, to request, send me a copy of what they filed with the Secretary of State, and they could have discovered it then. It appears to me that they just simply didn't show any diligence in pursuing this issue. And so, unless you are asking questions about that, we still contend that I guess one more point on that. To be clear with the burden of proof and the standard of proof, with respect to the filing deadline, the Nevada Supreme Court has never applied the substantial compliance standard to the actual filing deadline. They did apply it to filing the documents late in the Williams case, where in fact in that case they said, well, you filed the documents supporting the challenge 6 days late. We're going to say that the purpose of the statute was still met. In this case, that's substantial compliance. However, the challenge itself was timely filed. And in this case, because the new challenge to the affidavit does not relate back to the original complaint, it was not timely filed, and that is a mandatory and jurisdictional deadline, and they missed it. And therefore, the court should not consider that challenge to all of the affidavits at all.
As it concerns the notice issue, Mr. Benson, wouldn't you agree that Green Party would have already had notice with regard to that circular's affidavit and the issues as it relates to that?
I disagree with that. I think it's quite obvious that they did not have notice of that, or they wouldn't have circulated it, spent all this time running in the process of doing so. And that gets to this, why didn't they write a letter saying we detrimentally relied? I think it's obvious that they detrimentally relied. I don't think that's necessary to put in a letter or a declaration.
Okay. Right.
And so moving on to the burden of proof, with respect to the affidavits as their claim about all the affidavits, that they're making this argument that the one statement is missing and therefore ipso facto all of the affidavits are invalid and you have to invalidate all of the signatures. And they argue that this is based on LBCBA. So the LBCBA case is essentially the mirror opposite of this case in many ways, including the procedural history of how that case came about. And as Mr. Bice noted, what happened in that case was somebody noticed that the affidavit was incorrect, and the Secretary of State instructed the clerks not to verify the signatures. So the proponents of the petitioner in that case appealed the Secretary's decision. There's an administrative type appeal process. They lost, and then they went to court. And so the verification never took place. The signatures were never validated. They were never verified. The petition was never qualified. And so in that case, that's why the petitioner bears the burden of showing that they substantially complied, is because the petition never qualified in the first place. Here we have exactly the opposite situation, where the signatures were verified and the petition was declared to be qualified. And therefore, the burden is on the plaintiff.
Based solely on the validation of the signatures, though, not on the contents of the circulator's petition, correct?
I'm sorry.
So that was based solely on the signature verifications, not on the
That's
content.
one reason that's another thing I want to point out is this case has unusual, if not unique facts as far as I can tell, which is that the missing statement in this case, that the circulator believes the person to be a registered voter in his or her county, goes directly to one of the specific items that the clerks actually verify, and that the clerks are really the only people in a position to verify. And that is something that the plaintiff pointedly ignores throughout all of their arguments, is that is unusual because there already is an official process that checks for exactly that, as opposed to the statements in the affidavit, like to the effect that they've been given the chance to read the full text of the measure or as to the circulator's name and address. Those are things that obviously the clerk can't verify. And so we are not arguing in any form that, you should just get rid of the affidavit requirement because the clerk's verified signatures and therefore, it's fine. That's a straw man argument the plaintiffs are raising, and they ignore completely the unusual fact in this case that the one missing statement is something that is already accounted for in the official verification process. And so they gave you all these examples where the other courts have declared that, oh, well, because they don't have the number of signatures on there, it's invalid. They don't state that they read the laws and understood them, it's invalid, and so forth and so on. And yet those generally go to things that the clerks couldn't verify even if they tried. And this case is simply not that case. We have different and unusual facts in this case that make it easily distinguishable from LBCVA and those other cases as well. And so, because in this case, the clerks did verify the signatures, it was declared to be sufficient. The burden remains on the plaintiff to show that they do not substantially comply after the Secretary of State declared it to be qualified based on the clerk's verification. And you asked about this, the clearly invalid standard. What does that mean from the taxpayer's case? My understanding of what that means is that the plaintiff has to actually produce evidence showing that, in this case, almost 5,000 more signatures should have been thrown out. In other words, 5,000 signatures that the clerks already deemed to be valid should have additionally been thrown out. That they have to produce evidence to show that, as opposed to what I think the plaintiff has mostly done in this case, is conjecture and speculation about what might have happened because there are some corrections to some of the affidavits. They don't have any actual evidence to show that there was a signature party or something like that in this case. There's no actual evidence showing that any of those nefarious things happened. And so that's my understanding of what that means, is that they have to make the word basically a compelling showing that it is clearly invalid. And they don't get to do that simply through speculation and trying to shift the burden onto the Green Party.
Let me ask you this, Mr. Benson, as it relates to the petition requirement to have that circulator's affidavit, and the fact that there's that long affidavit. To say that because the verification of the signatures for the county clerks somehow validates what might otherwise be invalid, doesn't that make that statutory provision irrelevant and something that we don't ordinarily do with the law, to declare a provision null, not necessary, but it's specifically required under the statute?
I don't believe it does, Your Honor, for a couple of reasons. This is one, they make this argument that if there's something missing, it's ipso facto invalid. And if that were the case, then LBCVA would have been like a 3-page opinion. It wouldn't have this very thorough analysis that the court went through where it looked at, okay, well, is the missing thing, as they put it, an essential matter? And even if it is an essential matter, then was substantial compliance nevertheless met in some other way? They went through this very long analysis. And so just the fact that it's missing, the court evidently did not believe that that necessarily nullifies the statute. And in this case, we don't believe that is an essential matter for a number of reasons. First, as we already discussed, it is something that is specifically verified by the clerks, as opposed to other statements that the clerks would not be able to verify. It's also, the purpose of this statement is kind of not really clear what purpose it serves, because it's presumably to encourage voters to only get signatures from registered voters in that county. But that's the whole point of circulating a petition. That's why you're there, is to do exactly that. So, I mean, to make an affirmation on information and belief that you think they're registered voters, I mean, that's the whole purpose. Of course you're going to do that. And they talk about, oh, well, the only way you can know that is to talk to them. They did talk to them. Did they ask them specifically what the statute says? No, they didn't. I can see that. But they did talk to them and ask, are you a registered voter? Are you a Nevada resident? They're there with a petition for that particular account. They made at least, as opposed to the petitioners in the LBCVA case, the Green Party made a good faith effort to comply with the law, regardless of that statement being there or not.
How do you address the document that had Republican on it crossed off and then Green Party written in? How do you address the irregularities? Because I know in the replies and the responses that you provided, you point to certain anomalies, but over time, there's a number of them that call into question the integrity of the petition circulation. Can you address that?
Certainly, and I think that the plaintiffs, like I said in the sort of reply, have thrown a lot of things out to show what they say are all kinds of invalid signatures for all kinds of different reasons. But when you start to actually look at what they're talking about, like for example, the one where the Republican Party was written in, and I think that, excuse me just a minute, I think that was one of their exhibits in their PowerPoint. It was one of the exhibits to serve reply. And in that case, the Green Party name was pre-printed on the petition. I have no idea why somebody wrote Republican on there.
But can you acknowledge that over the course of the number of examples it's pointed out that it creates concern about how it was done?
I don't believe it does, Your Honor. I will say, circulating a petition, I mean, it's a human endeavor. There will be mistakes. That happens in every single case. And that's part of why we have the verification of signatures. So the fact that mistakes were made does not mean that anything nefarious is going on. It doesn't mean that there's some problem. As I pointed out in the server reply, for example, the plaintiffs claim that there's something like 2,700 signatures that are invalid in CD3 because of alterations. And when you start to look at what those alterations are, what they're talking about, it's very obvious that they're clerical mistakes. Like another one for in here, I believe it's on page 10 of their PowerPoint. They say, oh, well, they're crossing out the circulator's name and putting in somebody else's completely different name, and therefore they weren't there in front of the notary. That's just not true. I mean, you look at number 10, and you can see clearly what happened here is the person that looks like Dennis, I can't read it, Dylan, perhaps, the person who signed in the first box of the petition at the top, also started to fill out the circulator affidavit. It's the same name and the same address. And so that's a mistake by the signer. And the circulator crossed that signer's name out and put their own name in, which was the right thing to do to correct that error. That's not something that the circulator should be punished for. That's just simply a human error by the signer. And this has happened numerous times. These are the kinds of things that they're complaining about as being some kind of nefarious activity. It's obviously an error by the signer. Similarly, with respect to...
what about the one on page 9?
And that one I also addressed in the server reply. And that one, it's not clear to me what happened there. And that might be an example of where maybe the court should throw out that affidavit and signatures attached to it. But that doesn't mean you throw out all of them. What that means is you look at each affidavit, determine does this substantially comply. And if there's not some reason to say, okay, well, this is just a clerical error, maybe there is something else going on there, then maybe it should be invalidated.
But you agree, I mean, there's not the time to go through each individual affidavit.
I think my understanding of the burden of proof in this case is that is exactly what the plaintiff has to do in order to make a showing that it is clearly invalid. They have to go through every single affidavit and show why it is invalid or why it does not substantially comply. And I've done a lot of work in server reply, like for example, again, going back to the alterations to the journal. The part of the affidavit where it says so-and-so appeared in front of me and swore to this and so forth and so on. Of the 2,798 signatures in District 4 that they claim are invalid due to alterations, they cite, I think, 330 documents. 240 of those, the only change to the affidavit is where the notary and the circulator mixed up the name on that line. And that's it. And that affects more than 1,400 signatures. And so what they're trying to do here is they're trying to apply a strict compliance standard, which is clearly not the law. They're trying to apply a strict compliance standard where the slightest change, even if it's some kind of obvious clerical error, will render that affidavit and all of the signatures attached to it invalid. And that is simply not the law. And so I've gone through and I've shown that, in fact, the only documents that I could find where there was not some kind of obvious clerical error, where it would be like number 9 on a PowerPoint, I was able to find a total of, it looks like 23 documents affecting 156 signatures between CD1 and CD4. All of the rest of them fall into these categories of, there was a correction because the signer started to fill out the affidavit. There was a correction because the circulator and the notary mixed their names up on the draft. There was a correction to the signatures because somebody crossed their name out on the first page. And so the circulator originally wrote 7 signatures, and the cross out said, no, it's 6. In virtually every case, it was to reduce the number of signatures. And as I explained in the opposition already, the county at the top of the affidavit was not necessarily the county where it was circulated, but the county where the notarization takes place. And so if that was changed from the county where it was circulated, that's not a problem. There's nothing wrong with that. And so when you look at what the real problems, that I couldn't find a clear explanation for why those changes were made. I came up with 156 signatures between those 2 districts, and that's it. So I think that all of the other signatures, again, are clearly simple corrections, and that those substantially comply with the law because they meet all of the requirements of that affidavit. They show that the number of signatures that were on it, it has the circulator's name and address. It meets all of the things that the statute requires.
And your position is not having the correct circulator's affidavit is not fatal to the case?
Absolutely not. And that's, I think, very clear in LBCBA because, like I said, it would be a very short opinion if it were. They would not have gone through all these pains to analyze whether it's an essential matter, and even if it is, whether or not substantial compliance was still met in some other way. Like, for example, the plaintiff tries to say, oh, well, it's simply dicta where the Nevada Supreme Court said, well, if the clerks had done the verification, then maybe substantial compliance would be shown. Well, that's exactly what happened in this case. They did do the verification. And the other distinguishing factor here is that the only missing statement directly relates to what they verified, as opposed to the 2 statements that were missing in LBCBA were the number of signatures and that they had a chance to read the full text of the entry. And so that, so in other words, so the Nevada Supreme Court essentially laid out that no, it's not fatal. It's to have one missing. And here's other ways that they could have complied. And in fact, that's exactly what happened in this case. And with respect to the that missing statement, again, I want to emphasize that it's the touchstone here of substantial compliance is whether the document still meets all of the reasonable purposes of the statute. And if the answer is yes, then it substantially complies, even if there are statements missing. And as I explained in the opposition, this is really not an essential matter. One, because the clerks do verify that very statement. 2, it's only on information and belief. The circulators ask the voters, but they really can't verify in real time out in the field. And I think the other very telling thing is that that statement is not required at all for initiating referendum petitions. If the legislature thought it was that important, they would have included it in those circular affidavits also, because those are subject to the very same requirement that only registered voters of that county can sign the petition.
But I guess that's my point, and that's my question. You're saying that it's not required because when the signatures were verified, it establishes what that requirement was, therefore substantial compliance with all the requirements is there, and therefore it gets you there. But it's a specific requirement in the statute. And what you're asking me, or saying, is that this court should ignore that because those signatures, unlike the one in LVCVA, didn't get verified in that case, but they did in this case. So therefore it renders that particular requirement unnecessary.
In this particular case, on the unusual and specific facts of this case, it's not necessary for those reasons. I'm not asking you to strike the statute down. I'm not asking you to invalidate it facially. On the facts of this case, because the signatures were verified, then yes, the purpose of the statute has been made, it has been met, which is what substantial compliance means, is that has the purpose of the statute been met? And the answer here is yes, because they were verified. In LVCVA, the answer was no, because they have not been. So that is the distinguishing fact in this case. And I don't believe that that renders the statute a nullity. Like I said, I'm not making a facial challenge to the statute in this case.
And so let me clarify one more point. Your perspective is with plaintiff bringing this action with regard to the signatures, the issues that they've raised, the irregularities, that it's their burden to go through all of the pages of documents to establish the number of invalid or issues, present those in order to address the validity of the percentage of signatures or the raw number of signatures. Because what's being articulated is that the number of signatures that have been verified is, this is plaintiff's argument, that they're not technically accurate because it's based upon a percentage of valid signatures, which aren't truly valid based upon irregularities. But your position is it's their responsibility to go through all of them and demonstrate how many are not valid based upon the stated irregularities in order to properly challenge this case. Is that right?
That is my position in the burden of proof. And let me address this issue with the verification signatures on a sample. That's what happens in every case. That is the legislative scheme for verification of signatures. For petitions, we're going to let for ballot access. And so every time there is more than 500 signatures, they do a random sample and they apply that validity rate to the raw count. And so what the plaintiffs are asking is actually something quite extraordinary, which never happens, except in those very unusual cases where, you're within a couple of signatures of qualifying or not. They're asking for the clerks to verify 10,095 signatures. And that's just not, that is not the law. And the legislature prescribed these criteria to do a random sampling. And that's what the clerks do in every single case. And so there's nothing wrong with that. There's no reason why they should have to go through and verify every single one, because when they do take that sample, they'll find, as they did, as shown in the certificate of results, a certain number of people who are not registered voters. And that is part of the validity rate that they get. And so that will decrease the validity rate if there's a large number of not registered voters. And then they apply that and extrapolate it out to the rest of the sample. And so that should account for any other signatures of non-registered voters. That's the whole theory behind random sampling. And they're trying to essentially throw that completely out the window and apply a standard that has never been applied before, which essentially would prohibit random sampling. And so that is, I think that's a key issue that they're asking the court to apply a standard that just has never been applied to any petition as far as I know. And with respect to the calculations on the validity rate, they take issue with Exhibit 2 of the server reply. And in my opinion, and when we take one step back, I think the plaintiff agrees that they use the creative language that these problems infect all of these signatures. Well, as I said, it's a human endeavor. There will be mistakes in every petition. That's just a fact of life. That's why we do this verification. Why we use a random sample and we extrapolate the validity rate is to account for those other errors of all the documents where the clerks don't go through every single one. That is the process. And that is the process the legislature has deemed sufficient for declaring petitions of all different kinds qualified or not. And so where their argument fails, and where even if my client does have the burden of proof, I think we easily meet it in this case, is because all of the signatures that they say are invalid, they are presuming those signatures have not already been invalidated, or some portion of them have not already been invalidated by the clerks during that verification process. And that is simply an unreasonable assumption. There's no possible way that of their 4,800 out of almost 4,900 4,000 signatures plus out of 9,000 in CD4, for example, there's just no possible way that not any of them were already thrown out by the clerk. And so applying the validity rate that the clerk already found to those signatures is, I think, the most accurate way to account for the ones that the clerks would have already invalidated. And that is shown, I believe it's on table 4 or 3 of the SOAR reply. And instead they say, well, you can't, you have to subtract all of these invalid signatures from the raw count. But then you don't get to apply the validity rate. Then you have no idea what the validity rate is going to be, and therefore we haven't had our burden of proof. But what I did in Exhibit 2 is I used the same validity rate that the clerks found for each of the districts. And what that does is that effectively makes an assumption in favor of the plaintiff. Because if you remove all of these allegedly invalid signatures from the raw count before you do the sample, presumably the validity rate is going to be higher, right? Because you're going to remove all these invalid signatures before they even have a chance to be in that sample. And so I could have applied a higher validity rate, but I didn't. I made the assumption in favor of the plaintiff that the validity rate would still stay lower, would stay the same as it is, which I think that's not a realistic assumption. I'm giving them the benefit of the doubt, because if you apply a higher validity rate, then the petition qualifies by an even higher number. And so what I'm trying to show there is that by essentially, even if we have the burden of proof, which I'm not conceding, they simply haven't shown that enough of these signatures are invalid after you account for the fact that some of them have already been thrown out by the clerk. And I've made very favorable assumptions towards them in making those calculations. And that is also assuming other favorable assumptions that, one, they prevail on all of the legal arguments that these are in fact invalid signatures, and two, that there's no overlap between those categories. And those things, again, they don't really matter, because even if you make all those assumptions in favor of the plaintiff, they still haven't shown that there are enough invalid signatures to disqualify the petition.
How long has the Green Party been in existence?
I don't know for certain, Your Honor, but I know it's been in existence since at least 2020.
Do you know when the last time was that they qualified to be on the ballot?
I do not know that off the top of my head.
Because it lost the law, so yeah.
So if Your Honor has any questions or concerns about the mathematical calculations here, I'm certainly happy to expound on those more if you wish. But I think the bottom line is that the plaintiffs are ignoring the fact that some of these signatures that they claim are invalid must have already been invalidated by the clerks. And they don't even try to account for that in any way. And I think that it's improper to do that. They must be accounted for in some way. And I've tried to do that by making very favorable assumptions towards the plaintiff.
Well, even if we're talking about signatures that would have been invalidated by the clerks, what about the signatures that were notarized by Mr. Hansen? Do you want to address that?
Sure. And
Because I don't think that would necessarily be invalidated one way or another by the clerks.
And like I said, even if they weren't, when the clerks get the sample, they find a certain number of signatures are invalid, and then they apply it to all signatures, raw signatures, which necessarily would include some of them that were notarized by Mr. Hanson. And so if it didn't include those, then that means they must have thrown those out of the raw count, but I don't see any evidence that they did. I take that back, actually, I see some evidence that they did that in Washoe County on some of them. But it doesn't matter in Washoe County because they haven't arrived at insufficient signatures anyway, even without any adjustments in the count. But to the point, that's what like I said, they use this colorful language that these problems infect all of these signatures. Well, really what we're talking about is the signatures are the signatures. Those are the raw signatures. When they do that sample, it's going to necessarily include some signatures. They do the sample and the sample doesn't necessarily include the signatures, but the validity rate that they derive from that sample and then apply to the rest of the signatures does necessarily include all of the signatures, which includes the ones that were notarized by Mr. Hanson, which includes the ones where the Green Party was handwritten on, which includes the ones that have alterations to the affidavits, all of those things.
But you dispute that all of the signatures notarized by Mr. Hanson should be thrown out because you don't think that there's a conflict in that respect.
So the plaintiff relies notably on these out-of-state cases, which is a plurality decision anyway, that really focused on the people in that case were paid members of the committee, paid attorney, paid managers, etc. That focus on the monetary compensation that those people received in exchange for notarizing those documents. And there's been some other, there's a note in the cert reply, I think it's in, let's see, it's in one of the footnotes, footnote 7 on page 5. Other courts have rejected that very broad approach. And holding that, for example, only, even where the notary worked at the same law firm as the candidate, even circulated the petition, and notarized on some of the other circulated petitions, that was not, quote, direct interest. And furthermore...
But if a notary works at the same law firm as a candidate, doesn't mean that person's in support of it. Here we've got a notary who's a major part of the Green Party, who's notarizing documents on behalf of the Green Party for the circulation of this petition. That's not a problem?
And I think that, again, we need to look at what does Nevada law require? Because this direct interest test they misrepresent what the statute even says. That does not apply by its own terms to notaries. What the statute says is that the notary can't make notarizations in violation of these other provisions of the chapter. But they haven't shown that there are any violations of this chapter, any part of that chapter. For example, he's not notarizing his own statements. He's not notarizing a petition where he is standing to gain some financial benefit.
But he's certainly notarizing something that advances his own interest.
A political interest, it's certainly not a pecuniary interest, and it's that pecuniary interest that is the focus of the statute.
I think that's potentially arguable, but okay.
So, going back to, even if the court were to throw out all of those signatures, again, the petition still qualifies because there are still a sufficient number of signatures that are valid after you account for the fact that some of them would have been invalidated by the clerks in any event. And the same thing goes for the handwritten signatures, for the Green Party handwritten in. And if the court would like a document by document analysis on that, that's, again, it's my position that that's not my client's burden, that is clearly on the plaintiff to do that. Then I think that we may have to have a follow-up period to go through that process and see if it still qualifies or not. I think I've shown in the cert reply that it plainly qualifies easily, even if you assume that they win on all of those arguments, because they failed to account for the number of signatures that were already invalidated. And specifically with respect to the alterations, as I said, I was able to find only 153 signatures that were affected by some kind of alteration that was that there was no apparent reason for it, that there was no, it was not an obvious clerical mistake. And so
153 or 156?
I believe it was 153, did I misspeak? 156, you're right, excuse me. And so if the court is concerned about these, the signatures notarized by Mr. Hanson, and it strikes all of those signatures, if it strikes all of the signatures that have the Green Party handwritten in, the petition still qualifies because there are still a sufficient number of valid signatures, even or when you count one for the clerks, already thrown some out, but also when you look at the so-called alterations, there's only 153 signatures affected by that, not the 2,700 or something that they claim. The numbers that they claim are clearly, like I said, they're trying to apply this strict compliance standard where the slightest change renders the entire thing valid, and that is simply not the law. If you go through and you look at every single one of those documents, you'll see that the number that's actually affected is approximately 156 by my count. And so, even if the court were concerned about those other signatures that Mr. Hanson notarized or about the Green Party being handwritten in, the petition still easily qualifies. And so, I want to touch on a couple other quick points here. This is with respect to the constitutional claims. One, I want to make it very clear that these are as-applied challenges. We are not bringing facial challenges to any of the statutes or regulations. And again, this is limited to what I think are very unusual facts in this case. Because the plaintiff hasn't cited any case law. Frankly, I was not able to find any case law where the missing statement at issue is whether they're a registered voter, which is something that the clerks verify. Because I think that it just doesn't come up, it just doesn't happen. Because it is verified by the clerks. And so the constitutional challenges are specific to the facts of this case. They're as-applied challenges. And so with respect to the due process and the equal protection challenges, there's a couple distinguishing facts from LBCDA in this case. And the first is that in LBCDA, the petitioners used the old guide, which explicitly said, this is not force of law, etc., which the new guide also says. But the new guide in this case purports to be the 2024 minor party ballot access guide, and it contains the form with the wrong circulator affidavit. And the other distinguishing fact is, in this case, unlike LBCDA, the Green Party actually corresponded with somebody at the Secretary of State's office about the form, and the Secretary of State's office sent them the wrong form and said, use this to gather signatures. So on these facts, after they've gone and used that form that they were instructed to use, gathered all these signatures, the signatures were verified, they were deemed to be sufficient to now invalidate all of those signatures after the fact would be a violation of due process. And with respect to equal protection, the issue, again, as I already mentioned, is that this statement that they're a registered voter in the county if they're a resident is not required for statewide initiatives or referenda. And these are similarly situated, as a Florida court found in the Cleanup 84 case, that minor party seeking ballot access are similarly situated to those running initiative petitions. They're both seeking access to the general election ballot. They are both subject to this requirement that only registered voters of the county can sign that petition. And the signatures are verified by the clerks in the same process. And there's no rational reason, let alone a compelling reason, to treat these two differently. To say, well, you guys didn't have it in your minor party ballot access, even though it's completely not required when you're actually directly changing the law. That simply makes no sense. There's no rational basis to treat them differently. And so to treat a minor party less favorably than a petition circulator, because of that one missing statement, is a violation of equal protection. And to address some of the Secretary of State's arguments on that point, because the plaintiffs all address their argument, they make this very general argument, which again is in line with their theme throughout this case, where they pointedly ignore the fact that the one missing statement is a somewhat unique statement in that it is something that actually is verified through the normal process. And they argue, oh, well, if that's an equal protection violation, then that means the legislature can never prescribe different criteria for different types of petitions. And that's not at all what we're arguing. That is absolutely not what we're arguing. We're 100% they can require different things for initiatives versus minor party ballot access. But that's not the case here that matters, because what matters here is they are both subject to the same legal requirements that only registered voters of that county can sign a petition. And the statement goes directly to that matter. And it's something that is verified. And that is not required of initiative circulators, but it is required of minor party. And that is the equal protection problem. Again, we're trying to construct this broader oval. If you allow them to qualify, in this case, that means it renders the whole statutory scheme of having an affidavit a nullity, which is simply not true. That's not what we're arguing. We have very limited specific facts in this case that in no way would make it difficult for the legislature to prescribe different criteria. And so the Secretary of State, at least, and I will note that the plaintiff doesn't really engage with the actual argument about is there any difference between these two parties? Are they similarly situated? They don't even get to that. The Secretary at least makes an attempt to do so. But again, it's really, to the extent that there is any difference, it's not a difference that really holds any water or really changes anything. Like they make an argument, for example, that a person being presented with an initiative petition, because it's long, because it has to include the full text of the measure, has a better idea that that has something to do with voting. And therefore, it's not required to have the statement for initiative petitions if they're a registered voter, because the signer would know that. But that simply doesn't make any sense. I mean, they're being presented with a petition that's very short and simple that says, this is a ballot access petition for the Nevada Green Party. That very clearly relates to elections. I think, if anything, the opposite is true. That a signer is more likely to understand that they're signing something related to elections with a minor party ballot access petition than with an initiative petition, which, as Mr. Bice pointed out, we can sign a petition for all kinds of different issues. And initiatives and referenda are issue petitions. They're not ballot access petitions, which by definition have to do with elections. So I think that the Secretary's argument that a signer would somehow make the connection that this has to do with voting when it's an initiative, but not when it's a minor party ballot access petition, I think is actually completely backwards. I think the voters likely make that connection with minor party ballot petition. And so, moving on to the burden in this case, the Anderson-Burke balancing test. And it's a sliding scale, so the more severe the burden on the party's rights, the greater showing the state has to make in order to justify that requirement. And in this case, again, as applied challenge, the burden is severe because the Green Party has done everything that they need to do to gather the signatures have been verified, it's been declared qualified, and so to invalidate the petition now, after they've met all of those requirements, is a severe burden. They have otherwise gained the right to put their candidates on ballot. It's not just a possibility anymore. And so the burden is severe. So the state needs to have something more than just a rational basis for this requirement. And as I just discussed before, I doubt that there's even a rational basis to have this requirement because it doesn't appear to serve any purpose since it's not required for initiatives or referenda and because it's verified by the clerks. But they certainly haven't shown any kind of substantial interest or compelling interest. that, Your Honor, unless you have any further questions or concerns, I just want to reiterate that, one, this challenge to all of the petitions based on the wrong circulator affidavit, it's untimely, it does not relate back, because it alleges a completely new and different basis for relief than what was alleged in the original complaint. And there were no facts in the original complaint that would have put the Green Party on notice that this was going to be a challenge that was brought. And this challenge could have and should have been brought at the time of the original complaint, but it was not. And if the court considers that in any event, again, the facts of this case are somewhat the mirror image of LPCBA. In this case, the one missing statement directly relates to something that the clerks can verify. And as the Nevada Supreme Court recognized in that case, that could be substantial compliance. And in this case, it was substantial compliance because they did verify those signatures. And it was declared to be qualified.
Couldn't those signatures have been verified in LVCVA as well? I mean, I know they didn't get submitted, but they could have been after the fact to be verified.
And my understanding is that they were never verified in that case because the Secretary ordered the clerks not to verify the signatures. And in LVCVA, there were two missing statements. One related to the number of signatures on each petition, which was the one in relation to which the court said, well, maybe the clerks could have verified that if they had gone through the process. And then there was this other missing one about allowing people to read the full text of the measure. And the court found that both of those were essential matters. And because they didn't have either of them, the affidavit does not substantially comply with the law. And so essentially, the court, I guess, if it had just been the number of signatures, could have remanded to have the signature verified. But it didn't because they were also missing this other statement that the clerks had no way of verifying. And so that was another distinguishing fact. Here, the only thing that's missing is something that the clerks can and did verify.
You raised an issue too about the brief in support of the complaint and there not being one in support of the First Amendment complaint.
Correct, Your Honor. And that goes to the waiver issue, which is a distinct reason for the court not to even entertain the challenge to all of the circulator affidavits, which is that they filed the amended complaint, they did not file a supplement, they did not supplement their opening brief, they didn't file a new opening brief.
Is that required?
I think it is, Your Honor, in this case, because under the statute, they are required to file their challenge on time. They're also required to file all supporting documents and affidavits in support of that challenge at the same time. And in this case, when they filed the First Amendment complaint, they didn't even try to do that. They made no effort whatsoever to support it with any points and authorities, to supply any documents. They just supplied Exhibit 10 and 11, which were samples from Washoe and Clark, to show that, presumably to show that the affidavits were the same. But they didn't provide any points and authorities. Again, they are advancing this theory that the fact that one statement that's missing ipso facto renders it completely invalid, which that is not the law. That's clearly under LVCBA, that is not the law. And they did not even attempt to otherwise show why it doesn't substantially comply. And so by failing to support it with any points and authorities, they waived that argument. And that's been kind of, it feels like a theme also throughout this case, where the plaintiff didn't even try to file the documents in support of the complaint until about the same time our opposition was due. And so how is my client supposed to fairly respond to these allegations when it doesn't even know what signatures they're claiming are invalid or what? And the statute in this case clearly puts that burden on the plaintiff. So it's file all of its supporting documents along with its challenge. And admittedly, they had some issues with the public records responses, but again, they made apparently no effort until well after they had the documents to try to file them or to give notice to the Green Party about what exactly they were challenging and why.
In the Las Vegas Convention Visitors Authority case, it specifically says on one of the head notes, this court has repeatedly held that when an affidavit is defective, the signatures are properly stricken.
And the key here is when an affidavit is defective, what that means is that it does not substantially comply. And so,
So you're saying circulator's affidavit in this case was not defective?
exactly, because it substantially complies. Because when you look at all of these, when you look at that requirement, one with missing statement, it was verified. And the Green Party made an attempt to talk to the voters to see if they're registered voters, the signers, excuse me. And so in this case, they are not defective because that particular statement that's missing was otherwise satisfied for the purposes of the statute. That is what substantial compliance means. And if it substantially complies, then it is not defective and the signature should not be stricken. Any other questions, John?
Not at this time, thank you.
Thank you.
I'll be quick.
Good afternoon, Mr. Ott.
Good afternoon, Your Honor. I will be quick and get out of the way so that the capable parties can continue to litigate. Normally, the Secretary of State takes positions of neutrality, so I really only want to address the issues that kind of were brought forward by the communications between the Green Party and the Secretary's office, which really is the constitutional issues, and then the detrimental reliance issue, which was discussed briefly. With regard to the constitutional issues, the due process violation, I think, is adequately addressed by LBCBA. The facts here are very similar. The same disclaimer alerting the Green Party that this was not legal advice and to consult the statutes for the accurate recitations of the law were present in the guide there, as are here. So I don't think that argument is persuasive from the Green Party. And with regard to the equal protection, the case cited by the Green Party to move that forward is the Cleanup v. Heinrich Act, or case, and significantly different facts. There was a fee charge and a fee waiver was available to one class of petitioners that was not available to the candidates. That sort of dissimilar treatment is not present here. You've got two similar petitions, one a petition for a ballot access for a party and one for a petition to change the law. Similar affidavits as well with some small changes, so I don't think there's an equal protection argument that moves the needle.
Can you speak to the issue of why there's a different affidavit as it relates to referendums and initiatives compared to petitions to get on the ballot?
I don't have much to add other than what has already been discussed between the parties. I've not dug into the legislative history as to why they chose to deviate from those, why they chose to deviate between the two. So anything I would be giving would be conjecture. So, and then briefly with regard to the detrimental reliance, we touched on it slightly in our brief. There's footnote 3, which talks about how equitable estoppel is not available against the government when it is pursuing government functions. So the detrimental reliance really goes to that equitable estoppel issue. So whether or not there was detrimental reliance, I don't think it's relevant because you can't have the equitable estoppel against the government. So to me, that equitable or that detrimental reliance question is a non-issue. And then because you asked the standard with regard to the affidavit, I think both parties are agreeing that it's a substantial compliance standard. And with regard to the constitutional challenges, we think the rational basis test is the proper standard because there's no suspect class.
Okay. Thank you.
And I will tell you what.
So thank you, briefly, I appreciate you being very accommodating to us on the time, so I'll try and be brief on our reply here. It's probably going to deal with some of these in sort of reverse order here. We are not arguing. Counsel for the Green Party says that, well, sampling is part of the statutory scheme. We agree with that. Sampling is part of the statutory scheme. Just like the circulator affidavit is all part of the statutory scheme. We're not arguing that you can't do sampling. If the signatures had been, if the circulator's affidavit had been accurate, then the sampling process would have been appropriate. But just like in LBCBA, what happened was the affidavits weren't right, they are defective, those signatures did not qualify for verification. They weren't verified in LDCVA. The only difference here is the secretary didn't alert the clerks to the defects in the affidavits. That's all, because the secretary apparently missed it too. And we didn't find out about it until after they had already been submitted. And again, for the Green Party to argue we haven't been diligent here, that's a little bit much, I would submit. I think we've been very diligent. We submitted the public records request. We could not get a response. We could not gain access to the petitions. We couldn't even obtain a copy of what they supposedly had filed with the secretary back in 2023 in terms of the petition. But that's a very important point, because I'd ask people to look at page 8 of our PowerPoint. Because, this council argues this is a human process, errors are going to be made, there's nothing nefarious going on here. And then, we saw one of the initiatives where Republican was written in. So I asked the court, look at page 8. You'll notice up in the petition to qualify, there's a name written in, and it's later changed. But look at signature number 6. It's the name of the person that was signing this as number 6. So in other words, these petitions were being circulated without a party name, and signatures were being gathered on. That's not human error. That's shenanigans. Just like putting Republican down on a different one. So to characterize this as just, people here made a mistake here or there, those are not human mistakes. That's not, you were circulating a petition that was blank. The people couldn't have even known it was the Green Party, because it wasn't until signature number 6 on this page that line was clearly blank because the person wrote their own name on it. And then they later changed it. So all the signatures that they have obtained before that, this document was blank. And as we've shown you, there are a multitude of these petitions that are just all blank. That they hand wrote in Green Party, and then this one proves they were doing it after the fact. So this is not some circumstance where they can come in here and say, well, the burden is on the challenger here in order to disprove the validity of each one of these petitions. That's not the law. I'm sorry. LDCVA could not be more obvious on this. It just specifically says the burden is appropriately placed on the proponents in this case because they caused the situation when they failed to review the current statutes and comply with their requirements. It's interesting, in the LDCVA, they could have actually verified because one of the defects was what were the number of signatures submitted. The clerks could have looked at that simply and said, in that case, I will tell you, it was nearly 200,000 signatures because petitions required a lot. And Las Vegas Sands was backing that, and they spent a ton of money getting way more signatures than necessary. There was nothing that the clerks couldn't have verified on that. But the Supreme Court made the following statement. To hold that complete absence of these elements suffices for substantial purpose would render their inclusion in the statute nugatory, thus violating a basic principle of statutory construction. Counsel is telling the court, yes, we didn't include paragraph 5, a requirement that the legislature has imposed. We didn't include that, but that can be ignored, okay? That can be ignored because as long as the clerks verify a sample, although they didn't verify all the signatures as is being characterized here, they verified a sample of signatures, which I'll get to in just a moment, you can just disregard that requirement. Well, that would render the statutory language nugatory. It just wipes out the, because, by the way, Your Honor, by definition, every time, because this is a requirement for the petition and the ballot access for a political party, every time these get submitted, they have to be verified. So under counsel's argument, you can always delete paragraph 5 because the clerks can verify the signatures later on. So no need for it whatsoever. You just wipe it out. There's not a single circumstance where it's ever needed, according to the Greek party. And that is simply not the case, because this is actually the only substantive provision of that affidavit that requires them to communicate with the potential signer about what this petition is about. Because it forces them to ask the voter, the prospective signer, are you registered to vote in the state of Nevada presently and in this county where they are gathering those signatures? And they weren't doing that. And their own subsequent declarations where they're trying to salvage this after the fact prove that. They don't even have a consistent story about what they were teaching these people in terms of signing. Council also made the statement, if you look at the example we put on page 9 of our PowerPoint, council says, well, maybe that one should be thrown out, because here's just an example of where they're outright, the circulator's name is being crossed out in favor of somebody else. That right there is the entire problem. He said, well, you can throw that one out, or those, some like those, anything like that, those should have been thrown out. Well, they should have been thrown out by the clerk's office. And the problem here, Your Honor, is it's their burden to show substantial compliance, and they're here trying to use the clerk's process as the evidence of substantial compliance, while they're simultaneously acknowledging to you the clerk's process wasn't actually complying with the law. Because no one was looking at these affidavits because the secretary wasn't telling them to. And so these are the kinds of things that were going on, just like a petition was being circulated without an actual name on it. And there's no evidence offered by the proponent that to explain any of this. And it is, again, I'm sorry, this is where Mr. Benson and I just have a fundamental disagreement. Because the affidavit is wrong, LVCVA says the burden shifts to them. If they want the court, if they're going to argue to you substantial compliance, the burden shifts to them to prove it. And they haven't done that. They've instead tried to shift the burden on us to say, it's presumptively valid, so therefore they have to disprove substantial compliance. That's not what the Nevada Supreme Court said. They said, in fact, they just said the exact opposite. I apologize, Your Honor, my notes here, my handwriting is lousy. Another point that was raised, Your Honor, let me deal with this lack of jurisdiction, this argument about lack of jurisdiction. Again, I touched on when the assertion was we haven't shown diligence here. We tried to get the documents. We couldn't get them. We couldn't get them at all. In fact, I think we found out about 30 minutes before the filing deadline that the secretary said they had qualified. And we just found that out over the phone. We filed our lawsuit because we needed to preserve our rights. And under the law, under Rule 15, anything relates back to the date of filing that involves the same occurrence or transaction. What's the occurrence or transaction at issue here? Their ballot qualification. That's the occurrence or transaction. Our documents relate back, including by our amended complaint. And this argument to claim that a challenge is somehow different than something else is not supported by anything. And
I think the argument under NRS 293.174 is the specific language of the statute. His argument, and I'm sure you understand this, is that if challenged, all affidavits and documents in support of the challenge must be filed not later than 5 p.m. on the second Monday. His claim is that that's a jurisdictional issue.
Well, it plainly can't be a jurisdictional issue, Your Honor. I submit that the filing of the complaint may very well be a jurisdictional issue. But we file on time, and we attach, and in fact, we attached a copy of their petition that shows the defective affidavit. Right? His argument is, well, you didn't articulate clearly each and every defect in that affidavit. You pointed out some, not each and every one of them. All right? So this is timely. Rule 15 applies, and it relates back. Now, with respect to his other arguments, we didn't have those documents. How can we submit documents? We have been trying to obtain them. And this is not a criticism of the Secretary's office. The Secretary was, what they told us is they were working with the county clerk to get copies to finally produce them to us. And that took them a substantial amount of time. And then once we were able to review the actual, what we knew then were what they had submitted, you then realize, wait a minute, the affidavit is wrong on all, not just some, it's wrong on all.
Well, let me ask you this, if you didn't have the documents at the time that the initial complaint or petition was filed, what were you basing your arguments in terms of the invalidity of the signatures?
We outlined that, Your Honor, in the complaint itself. We pointed out, and we alleged, we noted, here are examples of things we have seen from the limited number that we have been able to obtain. And we
Did
put that,
that limited number have the circulator's affidavit on it?
yes, because, well, that was we didn't know that at the time, but that was the only circulator's affidavit that they had submitted. It turns out that infected all of them. Okay, so we only had, I believe it was 9 county,
I want to say line.
and Lyon, because they were, they're small counties, and the clerk's office was able to get us access to those very, very quickly.
Oh, it was 9, Esmeralda maybe.
Yeah, and I apologize, Your Honor, I can't remember each and every one of them. But the point here, and just going back to the, counsel says, well, he's been prejudiced by our delay. Respectfully, his client has these documents. They've had access to the documents far longer than we did. And they obviously knew that the affidavit was defective because they had submitted the original one, the correct one first. And you'll notice, Your Honor, they submit a lot of declarations to you, but you won't find one saying, we only learned when they learned about the defect in the affidavit. You don't see them disavowing that they knew about this defect, but then went forward with the signature gathering process because it was either too late or they'd already started it and they just went ahead and completed it. There's nothing like that. So I don't think it's really a fair characterization of the record to say, we haven't been diligent in this case. Plus, there's no prejudice here because you gave them a surreply, a substantial surreply, and we continued this hearing specifically to accommodate their request and ability to review all of the arguments. And that, by the way, is, and I apologize, I can't remember the site, I can look it up, but this is Wilson, Nevada Supreme Court, where they filed the complaint concerning the candidate's eligibility, but they didn't get the affidavit in until 6 days later. And what the court said there is, well, there's no prejudice. Yes, they didn't get it in on time because they didn't, in that case, Mr. Ferentz, the challenger, didn't have the private investigator's affidavit back yet. Well, in that case, Supreme Court said, but there's no prejudice here, and they substantially complied because the purpose of the statute is to expedite the resolution of these types of matters. The purpose of the statute isn't to say, gotcha, if you don't have everything on that exact date, well, I can't, no one can ever consider anything else. What the court said is, the purpose is to get that information in time so that candidate eligibility can be resolved. And here, the Secretary has agreed that as long as you address this prior to September the 7th, I believe it was that date, maybe it was the 6th, I apologize, I can't remember which one, there's adequate time to have this issue addressed by the court. And so there's no prejudice here to them. We have complied. In fact, they are the ones who had access to this information far in advance of what we did. And so with that, Your Honor, we continue to maintain that under LDCVA, the signatures cannot be allowed to move forward. This candidacy of the Green Party is not allowed to move forward because they just did not comply with the statute, and they cannot show that they substantially complied, and that is the burden. Thank you, Court, unless you have questions for us. Thank you. I apologize, Your Honor, I said I would answer a question for you. Mr. Brady found that. So here are the dates and the Bates numbers in our production, in our appendix. Of the dates when the circulator said he was in Reno and Washoe County and Clark County on the same date. October 28th of 2023, For Washoe, that is in volume 4 at 2681.
Volume 4 at 2681.
Yes, well, or is it 268, 1 and 2, Mr. Brady? Hold on.
2681 to 82.
Right? Then on, and Clark on the same day, which is in volume 7 of our appendix at 2711 and 12. And then another day, February 6th of 2024, he was gathering signatures in Washoe, which is at volume 4 at 3878. And also gathered signatures in Clark that same day, which is at volume 9, 6899.
Thank you.
Thank you, Your Honor.
Mr. Benson, any last comments?
Yes, Your Honor, thank you. So a couple points related, I guess, to the motion to strike first, is this argument that I recognize that they did not have the documents from Attorney Crochet, the Secretary of State, at the time they filed the original complaint. However, I believe it's set out in the motion to strike that they did get those documents. I believe it was June 15th and 17th respectively, from Washoe and Clark counties. And it was, when they filed the first written complaint on July 1st, they didn't file any, except for those small samples, they didn't file any of the documents that they were relying on at the time they filed the first written complaint. Again, it wasn't until well after that that our opposition was due, essentially, that they even attempted to file those documents. And the other issue here is, it's not just filing the documents, it's the notice to the defendant of what their argument even is. Why are they saying these signatures are invalid, and how many of them, and in which districts? We didn't get any of that until their reply. And so that's what I mean by sort of the lack of diligence here. And it's like now we're just now finding out that they're claiming other things are invalid for other reasons that we're not raised in any of the previous brief. And so I don't think that they've shown diligence in trying to file all of these documents, even after they did receive them from the clerks and the Secretary of State. And with respect to this argument that the Green Party had these documents and therefore there was no prejudice. Well, they had the documents until they turned them into the county clerks, and then they no longer had the documents. And again, the problem is the notice. We don't know which documents they're claiming are invalid or why. So whether we have them or not doesn't really make a difference. It's that lack of notice that is the problem. And it really doesn't further the purpose of the statute is to expedite this litigation. It requires the plaintiff file on time, file all the documents to support. And yes, the documents, we might get some substantial compliance if there are extenuating circumstances on that. But you've got to show your hand, basically. You've got to say what your problem is and why, and what you're relying on. And they did not do that until well past the statute of limitations in this case. The other issue that they talk about knowing about the defects of, that they say the Green Party must have known about this defect and proceeded anyway. Well, I think it's plain that they would not have knowingly circulated and spent all this time and money circulating a affidavit that they knew was defective.
What about the instance where someone's name is where Green Party should have been, and then on the next line? Wouldn't it be improper to be circulating that
And this,
for signatures without indicating who it's for?
well, so that goes to their claim that it's a handwritten party, and that, I noticed they only put the second page. I'm sorry, what page was that on?
Eight.
Page 8 of the PowerPoint. So they only include the second page of the petition. And I don't have all the documents with me. I would be very interested to see if the first page of this petition did have it written in there. And because, again, this may be one example where it wasn't written on the second page and the signer made a mistake. If it's written on the first page, then I think it substantially complies. And they make this argument that, the fact that we can see that there are errors, that it happens in circulating petitions, that somehow, is a concession that all of these things are wrong, which it's absolutely not. I mean, it's a completely unreasonable standard to assume that there are never errors, and that the fact that there are some errors somehow means that the entire thing is invalid. That is not why, that's why we have a substantial compliance standard. You don't
I
require-
agree, but I think it's also partly because you want to make sure that people know what they're signing, and when they're signing where the name of the party should be, that's problematic, right?
That's potentially problematic, but we don't know whether it was written on the front page or not. 'Cause they
It was
didn't include that.
clearly provided to that person without anything written in though.
Again, on the second page of the petition, we don't know if they saw the first page, we don't know exactly what happened in that particular case.
And how can we know?
And we probably can't. And so this is where, going back to the argument that, who has the burden, and Mr. Bice said we fundamentally disagree on who has the burden, because there is a presumption under law that the clerks have regularly performed their official duties, and that the verification was correct. So it is presumed to be valid. Therefore, the plaintiffs do bear the burden of showing that it is clearly invalid. But even if my client does bear that burden, I think we've shown it in this case. Because once you account for the fact that some of these signatures, maybe this one was already thrown out by the clerks. We don't know. But some of them must have been thrown out by the clerks. We do know that for sure through this process of random sampling and then applying that validity rate to the rest of the signatures. But they haven't accounted that in any way. And as I wrote in my SIR reply, we did account for that. And we accounted for it in a way that we gave plaintiff every favorable assumption that we could, which was that they prevail on all the legal arguments, including that all of these should have been thrown out. That there's no overlap between those categories, when in fact there is. And also the presumption that the validity rate would not have gone up had the clerks thrown these out from the lockout. Even with all of those favorable assumptions, the petition still qualifies. And so we've still met our burden, assuming that is our burden, of showing that the petition is valid. And to the extent, I think that the court would find that my client bears that burden of showing that each of these documents are valid. And I think that we have shown that for one. And I think that if we need to go through document by documents process of analyzing each for substantial compliance, that we can and will do that. But I don't think it's necessary in this case because as discussed in SIR reply, even granting all those favorable assumptions towards the plaintiff, it clearly still qualifies in all of the petition districts.
I'm still struggling with the circulators affidavit.
The fact that one thing is missing.
Yes.
And again, I don't want to beat the dead horse, but the LBCBA is a very long opinion.
I've read it
And,
more than once.
and so my point being is if one missing thing automatically rendered it invalid, what was the point of all of that analysis that the court went through? Why did it bother to decide whether this was an essential matter or not? Why did it bother to distinguish the Rodell case where it was deemed not to be an essential matter? Why did it bother to ask whether substantial compliance could have been met in some other way? Why did it bother to do any of those things if ipso facto is invalid because of this missing statement? And the reason is because it's not. That one missing statement does not automatically render it effective. And especially in this case, again, unusual facts in this case, where that one statement goes to something that the official process checks for specifically.
Thank you. All right, I'm going to ask the parties, both Nevada State Democratic Party and Green Party, to submit proposed orders in a Word document to the court as soon as possible.
I apologize, John, for Today is a Friday.
Friday,
I apologize.
Friday, August 2nd.
I'm not really that absent-minded.
No, I've got a calendar right in front of me that tells me the date, and sometimes I still read the year wrong.
I definitely had everything. Okay, so, if we got those to you on Tuesday, Wednesday, that's sufficient?
I'm assuming time is of the essence, because I would have to imagine that whichever way I decide, somebody's going to appeal, would be my expectation, and still try to get on the ballot by September 6th.
Mr. Brady is telling me that if you tell us you want them Monday, we will have them to you Monday. I'm gonna leave that to the court to give us, and to my colleagues over here. I don't want to presume to know what their schedules are.
Ms. Benson?
I believe I can get your proposed order by close of business Monday.
We will do the same.
Okay. I like the competition there. Okay,